That's great. So I'm chairing the next session, and I'm going to do a fantastic job. That's pretty obvious. So look, the next session gives us a chance to really look at the best interests of the child, look at the human rights law, and look at how it can make a difference, and look at some best practice examples that could inform and shape the Council of Europe recommendation, but also help in the reform of our legal system here in Ireland. We have 4 speakers. Our first speaker is going to be Michael O'Flaherty, who is Director of the Fundamental Rights Agency. Many people in this room are familiar with Michael. Some people would have studied with Michael when he was Professor of Law in Galway, Human Rights Law, or in Nottingham. He served as the Chief Commissioner in the Northern Ireland Human Rights Commission. He's been chairperson of the Irish Appeal and Reform Trust as well. And I have to say, I'm disappointed that he's not here in person, because I would have loved to have seen him at this event, but hopefully we'll get to see him again in the future at another session. And Michael has pre-recorded a video for us today, really touching on the research of the EU Fundamental Rights Agency. They've looked at this issue across Europe, and they have some key recommendations. They've also consulted with young people as well. So what they have to say is going to be really important, I think, for the discussions that you have today and tomorrow and on Wednesday as well. So I'll pass on now to Michael.
Good morning. It's my great pleasure to join you, even if it's just by means of a video recording, and I'm sorry that I can't be with you in person in Dublin today. I greatly welcome this conference. I welcome the initiative of the Council of Europe to undertake the work to develop recommendations on what the best interests principle looks like in practice in the context of care proceedings. This is yet again an example of the Council of Europe showing global leadership on an important topic. Our session is termed to be about the balancing of rights. And given that title, I think it's important at the outset to recall, of course, that the best interests of the child are never balanced against anything else. When we look at Article 3.1 of the Convention on the Rights of the Child, it couldn't be more clear. In all actions concerning children, the best interests of the child shall be the primary consideration. We find the same language in the EU's Charter of Fundamental Rights. And then when we look to General Comment 14 of the Committee on the Rights of the Child, it describes the best interests principle as one of the fundamental values of the Convention. Now, it's one thing to say that the best interests are inviolable, but it's another thing to figure out what that means in practice. It's often not easy to work out the contents of the best interests principle in specific circumstances. This has been a focus of research work by the Fundamental Rights Agency over a number of years. And while our work, of course, focuses just on European Union member states, nevertheless, we think that some of the learnings have wider relevance. I'd like to share with you now 4 of those. The first is the extent to which we find across many countries, surprising number of countries, a failure to, in any case, unpack the content of the best interest principle, or even to erect criteria by which the content could be determined. This is problematic. It's also problematic where, in the absence of attention to the best interest principle, countries point us to their existing child welfare provisions, which are sometimes quite old. And it's not evident to us that they have derived from the principle itself. Still, another consideration is the extent to which we find differing levels of attention to the best interest principle, where they exist, in different procedural contexts. For instance, typically, far more attention has been paid in the criminal context as opposed to the civil one. This is problematic. This is, for instance, a problem when a child is caught up in proceedings that involve criminal and civil aspects, such as custody in the context of a domestic violence situation. And then fourth and finally, we of course, and again this is not new and novel from us, but we have been confronted by the imperative need in all of our work in honouring the principle of the best interests to listen to children. we, across all of our projects in this area, seek out children and make every effort to listen to what they tell us. Let me share with you now just a few of their messages specific to our deliberations. They tell us that they find it traumatic to be involved in long, drawn-out proceedings. They don't understand, and indeed often they tell us it's never explained to them, why proceedings have to take so long and why all of them or elements of them have to be repeated. Children tell us that they've had the experience that they're asked for their views, but then they don't get the impression that their views are listened to when they express them. They tell us of moments when best interests are actually trumped in practice, where parental rights are given priority over the rights of the child, in the context, for instance, of visitation rights. And finally, children tell us repeatedly of what a difference it would make if they were dealing with people in the judicial context who know how to talk to a child, who know how to listen to a child, who know how to explain to a child, people trained in honouring and delivering on the principle of their best interests. Now, as you go forward, allow me to conclude with 4 suggestions of focus for deliberations and discussion. The first of these draws from our experience of the differing levels of attention in different contexts, and I would encourage us to cross-learn, to see where we can draw a best practice from, let's say, the criminal context that could be equally valid in a civil situation. The second suggestion I would make that's specific to civil proceedings in the area of such issues of custody has to do with the extent to which such proceedings, and this is to be welcomed obviously, move from a judicial to a mediation context. The issue here is to make sure that the best interest principle will receive as much attention in mediation as it might have in the judicial proceedings. The third of my 4 points draws from what I've said earlier, and that is the need for us to invest heavily in training of all relevant personnel so that they know how to work with children and they're aware of how to walk the path towards honouring the principle of the best interests in specific settings. And fourth and finally, let me come back to a point I made earlier, and that is to put the voice of the child at the heart of everything. Let's make sure the child is respectfully listened to in these most sensitive issues that engage the very heart of their human rights. Thank you.
I think you'd agree. I think that's a really good shaping input for our session today on that balance piece. It's not about balance, it's actually about the primacy of the voice of the child, and our reforms should be built around that. I'm now going to introduce Benoit van Keirsbilck from the UN Committee on the Rights of the Child to address the audience. Many of you probably know Benoit from his work as director of the Belgian section of the Defence for Children, and he's able to join us live here today, and he'll be able to stay for the discussion as well. So I'm going to pass over to Benoit. He met some of us from Ireland actually last week at the UN Committee on the Rights of the Child. So let me pass on to Benoit for his input.
Yes, hello everyone, and sorry for not being able to join you in person either. I'm currently in Strasbourg and working on a very similar topic because I'm involved in the redrafting of the Council of Europe help program on training for professionals in the field of child-friendly justice, so precisely the same topic as you are dealing with. So my intervention will focus on what the Committee on the Rights of the Child is recommending to states, because as you know, one of the mandates of the committee is to assess and make recommendation to states to implement the Convention on the Rights of the Child. And this work entails the assessment of how states are delivering concretely on the day-to-day basis their access to justice, the justice system, and how they are including the principle of best interest of the child in this regard. And so, just to recall, the first principle is that the Convention, in its preamble, recalls that the place of the child is in the family. So, having said that, of course, we have to analyze concretely what are the situations where a separation between the child and the family happens in so many different situations where with a parent is single mother, poverty is overall a huge cause of separation of children from the family, housing situation, incapacity of one or both of the parents to take care of the child, mental health problem, disability, drug, alcohol, migration, imprisonment of one of the parents, placement of the child for its protection, discrimination towards some categories of children, and so on. And we need to recall that most of those reasons should not be a reason or a sole reason for a separation of the child from the family. For instance, if we talk about poverty, which is still too much the main reason for this separation, it shouldn't happen like that. Society should have other means to deal with poverty, lack of resources, lack of housing. Many children are in vulnerable situations, such as abuse, exploitation, abandonment. Let's think of some states who put in place a system of baby boxes. So those boxes to receive children from parents who want to abandon them at birth. Of course, we can think that this is a way to protect them at birth, but what do we put in place to prevent all this? So what is expected from states to ensure that the system makes sure that the voice of the children will be taken into consideration, not only the voice, but the views globally. So we need to ensure that the states put in place a system, national plan of action for a systemic transformation of the child welfare system, develop strategy, and also with a view of deinstitutionalization, prevention of the separation, including for children with disabilities, with a clear time frame, budget, and also staff allocation mechanism for an effective implementation. All of this should be in place. So that means support of the family, preventing child abandonment, empowering families, but also changing attitude, encourage father to assume their parental role, which is too often not enough the case, strengthening family services, support social services, training. Training is key, as it was already highlighted by the director of the FRA. Ensure that children, when they are separated from the family, have their rights, all their rights fulfilled, and maintain a relation with the parents. Empowering youth also to face positively those challenges on everyday life. And we can also elaborate on all this because there are other important recommendations to formulate to the states. The states should also develop guidance, because when an authority, a judge, or sometimes other authorities have to assess the best interests of the child, we notice that very often they lack tools, they lack understanding of what it means, and they don't know exactly how to ensure that best interest of the child is effectively taken into consideration. And so having tools at the disposal, but also training. And training is not only theoretical training. This is a field where you can have some principle and some guidance, but you need to exercise, you need to see yourself dealing with the child and assessing this best interest of the child. And very often professionals are fearing to be in contact and in touch with the child just because they don't know exactly how to deal with that. And sometimes they fear to harm the child. which should not happen, of course. And I mean, there has been some interesting experience, like involving children who have an experience in the justice system, giving their feedback to judges to allow them to take a distance and understand how they should do better. So all this is, of course, needed to ensure that this notion is taken into consideration in the practice in all those situations where not only, you know, a decision in criminal justice system, but also in administrative proceedings, like in migration. Too often we see that migration board or migration authorities do not take into consideration the best interest of the child, and they often overlook the fact that a child is concerned by the decision that they will take. I have seen, have witnesses sometimes the situation where a child was in the courtroom and adults were talking to each other, not even noticing that there was a child in the courtroom. If I can give one recent example who shows how much the system has to improve, we can take the example of Ukraine. Ukraine is facing a huge crisis at all levels, is under attack, and I mean, we know all the consequences on the children. But we also see what were the difficulties that were in place before. Too many children in institution, lack of staffing, lack of capacity of the staff to ensure the well-being of those children. And in such a crisis, if we want to ensure that the rights of those children are taken into consideration, also when those children are displaced and taken in charge by other countries, we know how much we still have to work on that. We still have to work also on the situation of parental abduction, how you assess the best interest of the child when the parents are in two different countries and there is a dispute about who will take care of the child. In the enforcement of the visit right, to avoid use by force and taking the child out of the family and forcing the child to have contact with one of the parents in bad relation. So all those challenges are the ones we have to face when we want to guide the states on how to improve their capacity to deliver in this very difficult endeavor. I will stop here. I'm available for any question later on, and thank you very much for listening to me.
Thank you, Benoit, for that input. I think what really struck me was not only focusing on the voice of the child and how we do that, the kind of training and supports we put in place, but you really put the focus on the supports. We shouldn't be separating children from their families just because of poverty. And there's a real need to support families early on, to get the prevention and early intervention piece right, to get the family support piece right. This is all part of the story if we're going to be delivering the kind of outcomes that the EPIC Youth Council are really pushing us to deliver upon. I want now to introduce Dr. Carol Coulter from the Child Law Project. It's difficult to introduce Carol at this stage because there's so much in her biography. I first came across Carol when she was the legal correspondent in the Irish Times, and you were quite scary then, actually. And I had the great pleasure then to meet her in my new role in the Children's Rights Alliance, and I realised, oh my God, she's so nice and so generous. But that's the kind of, when people are working to the 5 o'clock deadline, that's the kind of pressure that they work with. Carol is leading the Child Law Project and is one of the founders. It's such an important project in Ireland because I know for us in the Children's Rights Alliance, it's very hard to know what's going on in the childcare courts. You're very reliant on the accounts of everyone who goes through it, and even the young people themselves don't go through it. You know, they're not part of the system in that way. And what this project has been able to do is give us an independent view of the issues going on in the childcare courts. Huge value to the young people, to the parents, to TUSLA, and to those of us as advocates in the sector who want to see better work, new reforms within this area. Carol's going to talk about the importance of transparency in this space, but she's also going to talk about the best interests and how that can be promoted through our work and through the Council of Europe as well. Carol.
Thank you, Tanya. Okay, well, I want to look at three areas where there is tension and a need for balance between key human rights principles and different parties in legal proceedings involving children. These include the right of families and children to privacy as against the general democratic principle that justice be administered in public. Assessing what different considerations, if any, should apply to children and families in child protection as opposed to private family law proceedings, because I think they are different, and then balancing the rights of the child and their family in proceedings as against the power of the state. For those of you who aren't familiar, I just want to very briefly explain who the Child Law Project is and what we do. It was established in 2012 to attend child protection proceedings and report for the general public, as well, of course, as for public servants, policy makers and other stakeholders. We do not report on private family law, that is, the proceedings which concern applications for judicial separations, divorce, domestic violence remedies and maintenance payments, which of course are also the subject of this conference. The reports are a narrative of the proceedings and published on a dedicated website, but we also analyse the data and information collected and publish analytical reports, including recommendations for reform. The project is totally independent, but is fully funded by the Department of Children, for which we are very grateful. We engage regularly with this department, along with other government departments and bodies, parliamentary committees and NGOs, on aspects of child law reform. To date, we have published almost 800 individual reports on childcare proceedings and 8 reports analysing the data collected, as well as making various submissions on child law topics. As our reports are published on an open website, they are accessible to the general public and the media, and this means the media can report on child protection proceedings and promote discussion on the issues raised without attending cases themselves. And for reasons I can't really go into here, the law allowing the media to attend either child protection or private family law is quite complex and difficult, and in practice they don't attend very much. But the coverage of our website reports has generated public dialogue on child protection, not only in the media but also in Parliament and among stakeholders. I want now to look at the need to balance the right of families and children to privacy as against the general democratic principle that justice be administered in public. The rule of law is defined as a principle in which all persons, institutions and entities, including the state itself, are accountable to laws that are publicly promulgated, equally enforced and independently adjudicated, and which are consistent with international human rights norms and standards. A public hearing ensures scrutiny of the judiciary and promotes confidence in the administration of justice. But beyond that, I think it's important to understand that this principle of the administration of justice in public enables the public to see how the laws made by the legislators which they elect work out in practice. And if these laws are seen to be flawed, the public can then seek their reform. It's thus one of the fundamental pillars of democracy, and I think should be restricted only in the most essential of circumstances, which do exist, because an exception to the administration of justice in public is permitted where the interests of juveniles or the protection of the private life of the parties so require. So access to these proceedings by the press and public is restricted in most jurisdictions. But in many of these other jurisdictions, the courts issue written judgments which outline the facts of the case and the conclusions come to. There are few written family law judgments in Ireland, except for those made in the higher courts. And the vast bulk of family law cases are heard in the district court and on appeal in the circuit court, with a lot of private family law in the circuit court. So for many decades, family law proceedings were covered by the in-camera rule, under which the proceedings were restricted to the parties and their legal representatives. None of their content could be revealed outside the court, including, in most cases, the decision. Anecdote, myth and rumour filled this gap in information, and it fed fear of family law proceedings, undermining trust in the judiciary and the administration of justice. It was clear a balance needed to be struck between the right of citizens to privacy on their family lives and the need to maintain confidence in the administration of justice. So consequently, legislative changes were introduced which did permit the reporting of family law by nominated bodies, principally academic and research institutions, and that's the law under which we operate. Different legislation permitted the press to attend, subject to a large number of restrictions. All three pieces of legislation stipulated correctly the anonymity of the parties should be ensured. And we have developed a protocol to assist reporters, our own reporters and editors, in ensuring no identifying details of the children or their families could be published. A copy of this is on our website. And as far as we know, we are the only body in Europe specifically dedicated to reporting on child protection proceedings in this manner. This means that in Ireland, a representative portion of the administration of justice and child protection proceedings is conducted in public while preserving the anonymity of the parents and children involved, thus striking a balance between the family's right to privacy and the right of citizens to scrutinise the administration of justice. I'd like to consider now whether we might need to balance the rights which require a different approach to the rights of children and families in childcare as opposed to private family law proceedings. Because one of the things we have learnt in the Child Law Project is that the issues in these proceedings are much more sensitive and delicate than those in private family law. The legislation providing for the taking of children into care by the state stipulates the health, development or welfare of the child must be at risk by remaining under the care of his or her parents. Inevitably, therefore, the cases involve allegations of neglect or physical, emotional or sexual abuse. In addition, our reports revealed the fact that the majority of parents in these cases are themselves vulnerable or disadvantaged. They may have a cognitive disability or mental health problem, suffer from addiction to alcohol or drugs, come from an ethnic minority or are socially isolated, and are usually economically disadvantaged. Many have experienced trauma, including abuse as children themselves and violent deaths in the immediate family. This is in contrast with the parties in private family law, who are generally, I think, representative of a cross-section of society. There is, as we've heard, also huge stigma attached to the taking of children into care. The type of evidence that is heard in such cases includes descriptions of the physical condition and hygiene of the home and the children, whether the child has been subjected to physical or emotional abuse, whether families or others are alleged to have sexually abused the child. These are matters which are highly sensitive and would be devastating for not only the parents but especially the children to come into the public domain. Child protection proceedings therefore present some particular challenges in including access to justice for children and their families. The parents may need assistance in understanding and fully participating in the proceedings. Judges, lawyers and court officials are likely to need specialist and trauma-informed training in dealing with those cases. Without such supports and additional training, fair procedures cannot be guaranteed. Children must also have a voice when the state intervenes in their families where they are deemed to be at risk. If they are taken into care, this can happen suddenly, and unlike in family law, private family law can thrust them into a strange family, away from their community, their school and friends. They have to face not only maintaining their relationships with their birth parents and their siblings, but with a foster family or staff in a residential institution, and these may not even be permanent placements. They have to navigate a new environment, and in some cases, they will have involvement in various therapies, all very challenging for a child. Mechanisms for ensuring that their voices are heard on these issues need to be tailored to the various stages of development of the child and be flexible, including access to their own legal representation where they are deemed capable of giving instructions. There will be additional challenges where the child has been subject to allegations of sexual or physical abuse. The police might be involved and may be conducting a parallel criminal investigation, requiring interviews with the child. It's imperative that the pursuit of two sets of proceedings do not lead to the duplication of interviews with the child, that they are conducted in a timely and sensitive manner, and that the requirement that evidential standards are met does not undermine the need to allow the child to fully express his or her feelings and wishes. And finally, I hope I'm not going over my time, but I do want to say something about the need to balance the rights of the child and their families in child protection proceedings as against the power of the state. In private family law, two individuals are in dispute, usually about family resources and arrangements for children following family breakup. In contrast, in child protection proceedings, the state itself, through one of its agencies, is bringing proceedings against one or more individuals seeking to severely limit one of their fundamental and constitutional rights, the right to family life. In seeking a care order, the state has at its disposal an array of educated and practiced specialists, most of whom are accustomed to giving evidence in court. The order is sought against parents who, as I've outlined earlier, are usually vulnerable, may have limited literacy, linguistic or cognitive ability, and be suffering from various other difficulties. It is difficult to imagine a more unequal contest. One of the core requirements of the right to a fair hearing, as guaranteed by the European Convention on Human Rights, is equality of arms, and another is the right to adversarial proceedings, meaning that both parties have access to all the evidence in a timely fashion. Access to legal aid where stakes are high is also required, and in Ireland this is provided by the Legal Aid Board to parents in child protection proceedings. But the particular circumstances that attend many of the families, combined with this inherent imbalance between them and the state, makes it necessary there are special efforts made to ensure equality of arms. It's imperative they have timely access to legal aid, and the proceedings are conducted in a way that permits them to participate fully. Supports for vulnerable family litigants should be part of the legal system. The Department of Justice is currently preparing reforms of the family justice system in tandem with the preparation of the introduction of a family court bill, which will establish a dedicated family court. Providing supports for vulnerable litigants is part of that discussion in which we are involved. The establishment of a dedicated family court with specially trained judges is essential to having a family justice system that is child-friendly, guarantees fair procedures, and produces the best outcomes for families. The establishment of such a court and the wider reform of the family justice system here in Ireland cannot come soon enough, and I will be very happy to hear about the experiences in other countries in the course of our discussion. Thank you.
Thanks, Carol, for that input. You've really taken us through the legal lens and the kind of reforms we need to see happen actually behind the closed door within the court. The thing that really struck me, I suppose, I mean, you're really reminding us of the principles, the justice principles, that we as a people, we need to see what's happening to be sure that justice is being done. But the other thing that really strikes me as well is the need for training and the need for special supports and legal aid for families. I'll have a question or two for you about what that looks like when it's translated into a strategy and law reform by the government. I wanted now to introduce Regina Jensdottir from the Council of Europe. She's the Child Rights Co-ordinator. She is going to provide us with the relevant jurisprudence, really, at the European level to help inform your discussions here tomorrow and the day after, but also the kind of reforms that are taking place in Ireland at this moment in time. Many of you have met Regina. She's been in her role since 2010. She's been the woman behind a lot of the reforms coming through in the Council of Europe around the violence against children and equality, discrimination and child participation. And many of you work with the tools that have come from the Council of Europe in your everyday work. So it gives me a great honour to introduce Regina to the stage and to take the floor.
Thank you very much, and good morning to everyone. I think as a civil servant in the Council of Europe, which I've been for over 20 years, believe it or not, you go through different tunnels, you go through different turbulent times, interesting times, moments which are challenging, some more challenging than others. And you sometimes lose sight of what you're doing and why you're doing it. And I think that it is extremely important to be present when young people like yourselves, when you come in and you explain to us the reality, which is so relevant for me to understand, and it helps me to again see why I do what I do. So I really wanted to thank you really very much for having prepared and having taken the courage to come and share information which is very personal and very important also for us to hear. So thank you very much. It was extremely important for me. Thank you. I would also like to thank the presidency of Ireland to the Committee of Ministers for having taken the initiative to organize this conference. I don't think it is a coincidence because for us in the Council of Europe, we have of course worked with all of the 46 member states for many years, but we see some states which take a particular interest in some specific areas for different reasons. And we have seen that Ireland has really taken the scene and is really in the forefront of making efforts to make sure that child rights are high on the agenda of the Council of Europe. And I think that this is also very precious to us because it does provide us also with political support in our environment, which is extremely important. So I wanted to thank you for making children's rights a priority on your presidency and of course for this wonderful event, stakeholders meeting, and hosting the expert meeting which will take place here as well over the next days. This is important because it gives us an opportunity not to meet each other online, but to come together in person, which also makes all of the difference. So thank you very much for the support. So why are we doing this work? I mean, sometimes I've been asked the questions, Regina, why are you looking at the best interest of the child in divorce and separation and in care proceedings? Well, I think it is crucial. I think we are now 12 years after the Council of Europe guidelines for child-friendly justice were adopted. It took a few years to prepare those guidelines, but I really believe that they are today a trademark of Europe. They have influenced legislation, they have influenced training, they've influenced the way in which we see children as the center of the judicial procedure whenever we need to take a decision for a child. So for me, looking at the best interest of the child, it is looking at the best interest of the child. You can say it, it's very easy to say it, but it's in the best interest of the child. How many times have we heard it? How many times have we seen this in judicial decisions, etc.? But what do we really mean by the best interest of the child, and how can we realize the best interest of the child in each and every situation where a child is actually in a proceeding or in a decision-making process, whether it's administrative, judicial, etc. And it's not easy. So I wanted us, with the work that we're doing in the context of the Council of Europe in divorce and separation, and as well as in decision-making for care proceedings, I wanted us to try to understand it better, to try to support those that have to take those decisions, difficult decisions, to understand better what do we mean by the best interest of the child. And the key word here is also determination, because determination, best interest of the child determination, is also a key element in that assessment, because each individual child is individual, and it is actually the determination of what is in that child's best interest which is the most important element here. And we've seen from the 4 participants of this morning, they are individuals, they had different lives, they had different experiences, and your best interest was different in each and every situation. So it's not easy to have such terms and concepts and principles in the UN Convention for the Rights of the Child and the way it's being interpreted by the European Court of Human Rights. So I wanted us to try to pull up the guidance we have seen from the case law and the jurisprudence of the court, from the work of the UN Committee for the Rights of the Child, and I wanted us to really put some flesh around the best interest of the child so that it would allow us to really take the right decision for each and every child. So we've seen, the best interest, of course, take center stage in proceedings in our member states. So, as I said, we really want to try to understand how to support the professionals and the persons that need to take those decisions. And during parental separation and care proceedings, there are other persons that also have a vested interest of the rights in questions. So the parents, for example, the best interest of the child should govern decisions on parental visiting rights during separation or divorce proceedings, as well as on the limitation of parental responsibility and even the right to maintain contact with children in care. So when we balance these rights and obligations of parents, it should be contingent to the determination of the best interest of the child. So the question of ensuring that the best interest determination is given due place in situations of parental separation, it may be very complicated by the fact that agreements with far-reaching consequences for a child, further upbringing, are often reached out of the courthouse in different administrations. So how can we make sure that everything links together? So as the different and sometimes conflicting rights, or apparently conflicting rights, unfold in these situations, the exercise of balancing child rights should be one of the fundamental steps in determining the best interests of the child in each individual case, taking into account the specific circumstances and the needs of the child. So historically, parents have had great power over their children. And I'm thinking about what Lim said this morning. The persons that took him into care and placed him into care, the nuns and the social workers, they had a lot of power, but they also thought they were doing what was right. So this is really, we also see the evolution of, what we think is right today in this room. Will it be right in 20, 30, 40 years? I don't know. Depends on how the world will be in 20, 30, 40 years. Anyway, coming back to what I was saying, historically, parents have had a great power over their children, but this has evolved. And we've come a long way in overcoming the conceptions such as that of children being property of their parents, or corporal punishment being understood as part of the right of parents to educate their children and to raise them. And in these situations, at least in theory, the balance is clearly tilted towards the best interest of the child. But there are other situations which I also wanted to draw attention to, which are very fresh in our memories. Children find themselves in situations of parental separation or divorce when parents sometimes are too focused on their divorce, which can be conflictual. And to assume their parental responsibility. So these situations can escalate to such an extent that external actors are duty-bound to intervene in the best interest of the child, to give the rights of the child a higher weight in the balance. And we need to find the right way of being able to do that, so that it respects the right of the child, the safety of the child, etc. During the COVID-19 pandemic, I think we were also particularly challenged. There were real threats to the best interest of the child. They really appeared, such as the difficulty of maintaining access visits between children and non-custodial parents, the exasperation of domestic violence exposing children to greater risks of abuse and violence, or the inaccessibility or shutdown of justice systems. So were we ready for that? I don't think so. In many countries, authorities, they struggled in the exercise to strike the right balance between the rights of the child, notably against economic and public health interests. This was really where we were trying, or we should have been more alert to the best interest of the child and the rights of the child and the obligations to respect the need to have the justice system also accessible during these times. But for some children, this was a very difficult moment because they were not at all able to see one of the parents. In cases of child abuse in the home environment, there is a need to balance the child's safety and the right to be protected from violence with the right to be brought up in the family, maintaining contacts with the parents, and in other words, a choice between removal of a child from its home or the family's right to have access to support or family therapy, for example. It also needs to be considered whether any other alternatives can be pursued in the best interest of the child. Likewise, in the case of domestic violence, the child's right to maintain contact with the parent having inflicted violence needs to be balanced with the right of the child to stay safe. So how do we do that? That's the big question. How do we do that? In care proceedings, as regards temporary or lasting removal of children from the setting where they live, the question is how to rigorously assess the direct and indirect impact for the child in the short and long term of a decision on placement in a foster family or an institution, and to pave the way for family reunification as soon as this is in the child's best interest. So no decision of this type, which may potentially do severe harm to the tie between the child and its parent, can in fact be consistent with the child's best interest if it is final, irrevocable, irreversible, and non-reviewable. Is that okay? The European Court of Human Rights, notably on the right for respect for family life, provides important guidance in some of the most conflictual cases, and this should also be our compass. How is the court in Strasbourg guiding us through that? And now I'm also speaking in the presence of Ksenia Turkovic, who is the former judge of Croatia to the European Court of Human Rights, and I'm sure she will be able to give us a very good insight into that. So please, Ksenia, I think you will probably complement me further in the program. But in parental separation or divorce proceedings, Article 8 has been interpreted by the court to require that domestic authorities strike a fair balance between the interest of the child and those of the parents, and that in the balancing process, particular importance is attached to the best interest, which, depending on the nature and seriousness, may override that of the parents. In particular, a parent cannot be entitled under Article 8 to have such measures taken as it would and could potentially harm the child's health and development. And when we look at the case law regarding placement and care, the court has explained that the best interest of the child needs to be assessed by balancing two interests, ensuring that the child develops in a sound environment and maintaining ties with the biological family, except in cases where the family proves unfit. So the court concluded that the balance should only tilt towards severing the family ties in exceptional circumstances, and that everything should be done to preserve family relations and, if and where appropriate, to rebuild the family. So finally, when it comes to cases of placement of a child for adoption, which entails a permanent severance of family ties, the best interest of the child needs to be a paramount instead of primary, and it is not enough to show that a child could be placed in a more beneficial environment for his or her upbringing. So if we go one step further, we might realize that even if we get to define how to balance these rights on paper, we might still fail to bring those rights to practice. So as we know, for any right to be more than just a promise, an individual must have means to enforce them. So for children, access to enforcement procedures is particularly problematic, and we are not really thinking of that, at least in my environment. It is not as evident to think of the enforcement proceedings. So they often depend on adults to bring those proceedings to the administrative authority or to the justice. So they depend on the adults to do so because children lack the maturity, they lack the legal capacity or the access to the information, legal advice, and legal representation in order to be able to access those proceedings, which are important. But even if there are no legal obstacles, the social norms, which still exist, they make it extremely difficult for children to have their views duly taken into account. So let's admit it. Behind many of the obstacles that children face, there is an inner conviction of adults that their voices are not important. And that's not what it should be. Ensuring the best interests of the child in practice, it implies listening to the child and accepting that his or her views may diverge from the opinion of the adult. This requires a sense of empathy, open-mindedness, and resourcefulness to truly come to appreciate the interest of the child. It includes trying to understand the social context or the lived reality of the child involved in a case so as to apply procedural and substantive legal principles in a way that respects the child's rights to the fullest possible extent. It's also essential to provide children with the necessary care, safety and security before they will even be able to exercise their participatory rights. So clarifying the concept of the best interests of the child and its implementation in practice through guidance for professionals, information to parents, to children in a child-friendly manner, notably in very complex situations, it is crucial. It's important for children and for children's human rights in general. It's really good news for children's rights that the Irish presidency has put these issues on the agenda. Because in most states, the best interest of the child in divorce and separation and in care, it's really the big elephant in the room. And we have the courage to really do something about it. Thank you very much.
Thank you, Regina, and I'm going to say thanks to all our panel because I don't think we have any time for questions now. So a big thank you to Michael, Benoit, Carol and Regina. I think what you've managed to do with those 4 inputs is really tease out the complexities in this space and what the kind of challenges are if we want to try and get reform going in the right direction.